Hello again, I'm attorney Robert Flessis for Robbins & Lloyd Career Training Institute. This video is part 2 of course 6, case law updates. There aren't that many new cases to tell you about, so I'm going to update you on some interesting things going on with the law as it relates to real estate. We're going to talk about administrative rules and potential new legislation that may be put into law. The first thing that I want to let you know is that the 2023-2025 Wisconsin state budget eliminated the personal property tax. This tax was enforced on commercial property, which includes commercial leases. This elimination will benefit now small business owners because they won't have to spend their time, first of all, valuating their personal business property like desks, computers, chairs, printers, kitchen equipment, and other associated items. According to the 2023 Realtor Legislative Report, during the 2000s, the state only collected $202 million on personal property taxes versus $1.2 billion collected in 1971. That's a big difference. Small businesses are struggling to stay alive. Maybe this change will help them. The Department of Professional Services will see a pilot program that may help DSPS save time and money by allowing private continuing education providers like Robbins & Lloyd to certify that a real estate licensee completed their continuing education through the private provider. This change was also enacted through the 2023-25 state budget. The Wisconsin Department of Revenue expanded the scope of their digital goods guidance. This means that the DOR is looking to collect what? More taxes. The import here is that digital goods are expanded to include online databases. Who do you think this may affect when it comes to real estate? The MLS database accessed by users. The digital goods definition before this change targeted online databases that disseminated information, which is comprised of databases for news. Currently, MLS services that compile information related to compensation and broker cooperation is tax exempt. The WRA is lobbying our legislature to clarify the DOR's scope so it doesn't affect the real estate industry here in Wisconsin. The WRA will seek to change some provisions in Wisconsin Statute 452, which is a statute that regulates you as real estate professionals. Apparently, the WRA wants to see increases in fines and forfeitures for licensees that commit law violations. The WRA also wants to see new legislation that requires wholesale buyers and sellers to provide written disclosures that relate to the purchase and sale of the property. We talked about disciplinary actions in course 2, and you may have noticed that most of the fines were small and the discipline wasn't powerful enough to prevent others from violating the statute. We'll see what happens. We're all quite aware of housing discrimination, which we're going to revisit in course number 10. Even though there are anti-discrimination laws, there are still discriminatory covenants that are based on race and other protected classes that you can still find in deeds, subdivision restrictions, and covenants in our state. I don't know how many people actually read deeds and other restrictions, but unlike discriminatory practices, there is no law that allows the removal of discriminatory language from deeds, covenants, and subdivision restrictions. The WRA is seeking legislation that would give a property owner the right to act when they find a discriminatory restriction on their property recording. That'll be interesting to see how this future legislation intends to allow changes to real estate records. Here's another idea that's going to be explored to generate more sales when it comes to property that borders the Great Lakes and commercial rivers. Much of this property is already taken and it's expensive, but there are still issues as to who owns land that is now underwater. The issue here is that a lot of land that borders waterways was apparently underwater more than 40 years ago. Property owners go to court with disputes that go to property ownership as it relates to shoreland. Often, nobody knows who owns certain shoreland property. The problem is that this affects whether lenders will loan purchase money And will title companies insure over these unknowns? These potential roadblocks affect whether or not a buyer will proceed with a purchase. Potentially new legislation is thought to enhance economic activity where title issues cause issues for prospective buyers. The WRA works hand in hand with legislatures to improve the viability of the sale and purchase of real estate. According to RPAC, which stands for the Realtors Political Action Committee, they have had many successes with helping develop new legislation. There was a long list of successes in the 2023 legislative report. You could see them. Here are some of their successes that they reported in their update. Elimination of farmland conversion fees, deductibility of health savings accounts, wetland regulation reform, protection against joint and several liability, accountability for fraudulent misrepresentation by sellers, reform of the landlord-tenant laws, protection of the right to place a peer, funding for broadband expansion, elimination of rental weatherization requirements, landlords are going to cheer, preservation of property tax cuts, implementation of the 2-year statute of limitations on liability for you, funding for private septic systems, preservation of the rights to rent your home, clarifying the definition of defects and inspection reports, and a prohibition on home equity theft by the government. As I said, these are all outlined in the 2023 RPAC report. RPAC is a very powerful political organization that's part of the WRA. They're keeping you in business by watching and changing government regulations. The last case that I want to talk about may be familiar to you. It is the U.S. Supreme Court decision in Alabama Association of Realtors versus Department of Health and Human Services that was decided on August 26, 2021. This is the case that stopped the government from continuing a ban on evictions affecting 80% of the nation's landlords. The purpose of discussing this case is to look at the reasoning behind the court's reversal of the moratorium. My discussion will give you some insight into how government operates and when the courts will overrule the government when the government violates the law and operates to damage landowners. Well, due to COVID, the case states that the CDC imposed a nationwide moratorium on evictions of any tenants that live in a county that experienced substantial or high levels of COVID transmission and made certain declaration of financial need. The plaintiff that sued the government obtained a judgment from a district court, but the court's ruling, striking down the moratorium, was stayed pending the government's appeal. The Supreme Court stated that the district court ruling was correct and that the CDC didn't have the authority to oppose such a moratorium. It was up to Congress, remember that, Congress, to grant such authority to the CDC, which it did not. Administrative agencies seem to think that their authority supersedes congressional authority, which they think they're a fourth branch of government, and it's not correct. This is exactly what's going on in our country. Agencies are ignoring the Constitution. They try to ram new laws down our throats when they don't have the authority to do so. In this case, the CDC imposed a nationwide moratorium on evictions. They relied on a very old statute that authorized the CDC and/or other agencies to implement measures like fumigation and pest extermination. Well, the Supreme said that was a big stretch by the CDC. And in March of 2020, Congress did pass an act to alleviate problems caused by COVID and imposed a 120-day moratorium on evictions only for properties that participated in federal assistance programs or were subject to federally backed loans. When this congressional moratorium expired, Congress did not renew it. The CDC just blew past Congress then and made up its own rules that went even further than the original congressional act, making the moratorium applicable to all residential properties nationwide and imposing criminal penalties for violation of their rule. The CDC moratorium was to expire on the last day of 2020. Congress extended it for 1 month, and when the new deadline approached, the CDC took matters into their own hands and extended its moratorium through March and then through July of 2021. The CDC was digging up and dusting off a very old federal act of 1944 to justify their imposition of a continuing moratorium. The court said that the provisions the CDC relied upon was rarely ever invoked and never used before to justify an eviction moratorium. Well, realtor associations on behalf of property owners sued the CDC to stop this unlawful moratorium that deprived landowners from earning their rightful income. The Supremes even noted that it's difficult to imagine the plaintiffs, which were realtor associations, losing the case. The Supremes likened the CDC's far-fetched reasoning that its authority could mandate free grocery delivery to homes of the sick or vulnerable, or, for example, require manufacturers to provide free computers to enable people to work from home, or order telecommunication companies to provide free internet service to facilitate remote work. They said that the CDC's claim to authority was unprecedented. And they laughed at the CDC's penalty provision as well, which was a fine up to $250,000 and 1 year in jail. What? Did the CDC ever read the Constitution? The court further stated that the moratorium put millions of landowners across the country at risk of irreparable harm by depriving them of rent payments with no guarantee of eventual recovery. The court said that preventing landlords from evicting tenants who breach their leases intrudes on one of the most fundamental elements of property ownership, and that's the right to exclude. Congress failed to act to distribute rental assistance funding to transition from the moratorium. They dragged their feet on funding landlords, but never seemed to drag their feet when it comes to increasing their salaries and benefits, right? The court stated that the public does have a strong interest in combating the spread of COVID, but our system doesn't permit agencies to act unlawfully, even in pursuit of desirable ends. The government broke the law and could care less. It was up to Congress, not the CDC, to decide whether the public interest merits further action. The court's opinion concluded with these words. Listen carefully. If a federally imposed eviction moratorium is to continue, then Congress must specifically authorize it. See, the Constitution protects citizens from the government, and the Supreme Court makes the final decision, which in this case was correct. And I hope you appreciate what I just told you. Well, that's it for part 2, and I'll see you in part 3.